July 17th, 2012, and this is our Smartcast Protected Concerted Employee Activity. And our agenda for the next several minutes that we have together is we're going to look at Section 7 of the National Labor Relations Act. Now, a little history on that. The National Labor Relations Act is actually the same thing as the Wagner Act, and that was passed in 1935. It's also the law that created, I should say, the National Labor Relations Board. And of course, that oversees the sanctioning of all unions. Now, don't think of this, even if you have a union, please don't think of this Smartcast as a union-type issue, because it's not. There are protections that your employees have, and the National Labor Relations Board, through the National Labor Relations Act, is expanding those protections. You need to know about that, and that's what this Smartcast is all about. Now, the Wagner Act, just a little bit of history on that. The Wagner Act is widely regarded as the law that authorized and legitimized collective bargaining. Before that, people were beating each other up and all that kind of stuff. Now, employers in 1935 saw the National Labor Relations Act, the Wagner Act, as being a big grab by the unions. And it wasn't until 1947 with the Taft-Hartley Act that the pendulum sort of swung the other way and management felt like they got some of their rights back. And that is basically, between those two laws, the collective bargaining world that we have today. But we're not going to talk about collective bargaining. Everything in here applies to that, but it also applies to non-union settings. And that's the part that we're going to emphasize here in the next few minutes. So we're going to look at Title VII. We'll define it just so you can get a technical definition for that. What is lawful, protected, concerted employee activity? We all should probably know that as employers, right? And then we'll look at some case law, very, very recent case law, really from the last 60 days, so about as current as it gets. And see what kind of things we can learn. There's some do's and don'ts from the NLRB but when I read them, I thought, I can update our handbook on this kind of thing. And you might feel the same way. And then we'll take some questions, and then we'll call it a day. What is concerted employee activity? Well, it is the right to engage in certain types of concerted activity. And it was written into the original 1935 National Labor Relations Act, Section 7. And here's what it says. It says, employees, this is right from the law, employees shall have the right to self-organization, that's the union thing, to form, join, or assist labor organizations to bargain collectively through representatives of their own choosing. And this is the catchphrase here that I want you to really stick on, comma, and to engage in other concerted activities for the purpose of collective bargaining. And here's another conjunctive term, or. Doesn't have to be collective bargaining. It can be mutual aid or protection. It's that part. It's that very, very last part that we're largely going to focus on. This is not going to be a union presentation. It is going to be a presentation about what are the rights of employees to engage in other mutual aid or protection for themselves. And it shall also have the right to refrain from any or such activities. In other words, an employee can say, hey, let's engage in this employee activity, this concerted activity. Another employee can say, you know what, I don't want to do that. And they go, well, come on, you got to do this. And the employee says, no, I have a right not to do it also. Okay, so that's what that means. What is protected activity? Not concerted activity now. What is protected activity? Well, I've got a couple of cases here. Now, these are kind of old. These are just sort of benchmark cases, that have withstood the test of time. KISOR, petitions and groups approaches to the employer. So some of your employees come to you as an employer. They come to you with an issue here. Where do we draw the line in terms of what they can legally ask you, and you have to provide, and you have to cooperate, versus you don't have to cooperate. Where is that line drawn? Well, here's a couple of cases that deal with that. One from 1992, Kaiser Industrial Corporation. It says that employees jointly asking a supervisor for clarification of work assignments. That happens every day. That happens every day. And apparently that went to court because the employer said, will you guys just leave me alone? You don't have to be asking me. I told you once before. No, that was held to be protected. Employees can get together and confront a supervisor or a manager for clarification of work assignments. You might have a bad manager out there, and that person is vague in the assignments, or do whatever you want, or whatever you think is best. You know, some employees don't feel comfortable with that. They're highly structured in their thinking, and so they're going to say, you know what? No, I got some role conflict here going on. I need clarification on my assignments. I don't feel good about just winging it. Well, that kind of a question, if you get something that even sounds like that, remember Kaiser Industrial Corp. It's protected. You have to be kind and help your employees. Mass advertising and publishing, 1991. Employees essentially presented a grievance together. Okay, pretty clear stuff. I mean, this might have been in a union setting. Probably was because it was under NLRB, but it doesn't have to be. This is the point. You can have a number of employees come to you and say, you know what, we have had it. You know, that manager we're dealing with over there, you know, the guy, you know, him or her swears, he's a bully, she's a bully, you know, tells bad jokes, wastes time, you know, whatever it might be. And it's something that the employees perceive as a legitimate complaint. They can come to you with that complaint, and that is considered a grievance in NLRA speak. And when they prevent that grievance, you can't just push it aside. You have to listen to the grievance, treat it seriously, and if in fact you deem that in fact it is a legitimate grievance, you have to take action upon it. Are you doing that now? Well, that's what the law says. Concerted complaints to state and federal agencies. Boy, we all get nervous about this with as employers. You know, the world goes something like this. Employers know that there are certain areas when an employee, while they're an employee, there are certain areas where they have a lot of rights. And if those rights either are ignored or violated, it's like, you know, pick up the phone and call the EEOC. I hear a lot of that stuff. Or somebody gets terminated for performance. Boom. They get a lawyer. They feel like they were wrongfully dismissed. And the lawyer knows where the skeletons are in the closet. What they're going to do is they're going to subpoena the job description. If that's not ADA compliant, you've got a big problem on your hands. All the stuff that we've talked about in general on these Smartcasts, all this stuff kind of comes together. You've got to be compliant on all this. Well, here's a couple of cases where a couple of companies weren't exactly up to snuff on that. In 1993, Delta Health Center, employees' communication to a government agency, in this case the Public Health Service. Now this is a health center. Don't have a lot of detail on it. They didn't give us a lot of detail, but it's a health center and they're complaining to the Public Health Service. Doesn't sound good. And when they did that, management got all hot and bothered and tried to retaliate against these employees. But the NLRB stepped in and said, you know what, that constitutes an employer's major funding source is protected. Let me start that over again. The employee's communication to the government agency constituted an employer's major funding source, and it was therefore protected. It was protected. In other words, the employees had the right. They had the right to go. It felt like it was a last resort to contact a federal agency for the concerted protection of themselves and protected activity under the NLRA. Pete Odell and Sons Steel Erectors, 1985. Employees meeting with the U.S. Army Corps of Engineers. Okay, got the government involved here, the military. And they got together with them, these employees, to discuss employers' compliance with the Davis-Bacon Act. Davis-Bacon Act, 1931, is the law that says if you take if a private company takes a federal contract for construction, Davis-Bacon was construction, and if you take a federal job for construction, you have to pay the prevailing wage. Well, without going all into that, that ultimately is the union wage. So anyway, these employees meeting with the U.S. Army Corps of Engineers to discuss the employer's compliance with Davis-Bacon is protected where the union initiated the Corps' investigation. So management wasn't too crazy about that because they saw that it's going to cost them a lot of money, but that was protected activity. What is lawful, protected, concerted activity? Now, here's some questions just to kind of ask yourself and kind of get your arms around this issue here. Number one, is the activity concerted? In other words, is it one person who's coming to you and saying, this, that, or the other, or is it a concert? Is it concerted? In other words, there's a number of people who have joined together to bring up a topic, to bring up a complaint, to raise an issue, to call somebody, and they're doing this for the mutual benefit of one another, and I'm talking about the employees. That's the first question under Section 7 of the NLRA. Is it a concerted activity? Well, is it? And you have to make that determination. Sometimes it's kind of hard to tell, but a lot of times it's pretty simple. So if you have a bunch of employees coming together and say, we are in unison, in agreement on this thing here, and we want something done because it's a safety issue, we're losing sleep because the boss is a terrible boss, or whatever it might be. If there are people together rather than one person, it's the collection of people that makes its concerted activity, and the protection then falls under Title Section 7 of the NLRA. One person coming to you is one person, does not fall under the protection of the NLRA. Number two, does it seek to benefit other employees? Because it must. You can't have one person who's just kind of a fairly strong-willed person and gets a bunch of people who are kind of followers, and he or she is the spokesman for this, and you find out that in airing out what the issue is, that it really doesn't benefit other employees, it benefits one person. That does not apply. If, on the other hand, if employees come to you and they say, whatever they want to have done, if at the heart of the matter, if the heart of the matter is that it benefits other employees, that is protected concerted activity. Number three, is it carried out in the way that causes it to lose protection? Now, there's two words in this whole thing here. There's protected activity, and then there's concerted activity. Concerted is a bunch of people together. Protected activity is statutory. Protected activity is the statutory stuff in Section 7 of the National Labor Relations Act. So in carrying out the gripe, the grievance, the activity of the employees, are they doing it in such a way that that they lose protection under Section 7 of the NLRA? If they are, that weighs way against the employees, because now they're doing, in essence, unprotected activity, and the employer can squelch that. Okay? What is lawful, protected, concerted activity? Employees shall have the right to self-organization. Okay, that's union. To form, join, or assist labor organizations, to bargain collectively through representatives of their own choosing, and to engage in, this is the part for non-union employers, which is, I know, is probably most of you, but it does apply to union employers as well. But the employees have the right to engage in other concerted activities for the purpose of collective bargaining, here's the big part, or other mutual aid or protection. Mutual aid, one for all for one. Group of people, we're all going to benefit from this. It's concerted activity. And she'll have the right to refrain. So in other words, somebody can say, look, I want to keep my nose clean. I don't even though I know I got the rights, I don't want anything to do with it. Leave me alone, leave me alone. So these are the laws. I'll just stop here for a moment. How many, things happen in in the course of a year when you're dealing with employees that might fall into either one or two categories? One, it's protected under Section 7. Maybe you don't know what Section 7 of the NLRA reads. Well, you should. And once you know that, how many times do people, two or more, come to you with something that is really for the benefit of either that group of employees or that group and other employees? And it may seem kind of egregious to you at first when you hear that, but the words are concerted activity, and that's protected under federal law. So it kind of puts a different spin on listening to employees and what they do, and this has been expanding through the years, as we shall see in a minute. So what is lawful, protected, concerted employee activity? Here's some examples. These are not all that old either. A lot of social media stuff. Social media, by the way, is really a troublesome issue for this whole matter. 5 construction employees were fired after several of them appeared in a YouTube video complaining of hazardous working conditions. Didn't ask management, did a YouTube video, and they complained. Construction workers complained. This company here is making us work in hazardous working conditions. That was protected concerted activity. It benefited a number of people. It was a legitimate issue. In this case, it was safety. It's all covered under OSHA. Number 2, a customer service representative was fired after discussing wages with another employee based on a policy in the company handbook that the NLRB found was unlawful. Oh boy, this is all over the place in the United States. People have handbooks that say it is confidential information to do not talk about your pay, your terms and conditions of employment with other employees. That is illegal. That is illegal. That will never be held up if you have that in your handbook. You got it in there. You got something there the dog's not going to hunt. You can't have that. That has been held numerous times to be unprotected activity because employees may want to talk about wages with one another because they're engaging in a concerted activity to better themselves, and that's all right. Number 3, a paramedic was fired after posting grievances about her supervisor on Facebook. Probably not good form, but that's what happened. So she gripes about her supervisor on Facebook following a work-related incident. So something happened, she got kind of ticked, and she goes, well, I'm gonna blast this guy on Facebook. Well, that was protected concerted activity. An employee fired and threatened with deportation after he delivered a petition protesting their poor living conditions and irregular hours that was signed by several dozen welders who were performing contract work on a temporary basis. Goes on a little bit more, but that's the main part. Threatened with deportation. That's a retaliation kind of a thing. And so the employee said, you know what, poor living conditions, deportation, we've got to do all this kind of stuff, This is not for the betterment of the whole group. Why don't we get together here and try and see if we can make this better for ourselves, improve these working and living conditions besides. And the NLRB says, you know what, that's okay. The employer can't penalize them for doing that. So I don't know if he was reinstated. I don't know if he or she, I don't know, they wanted to be reinstated, but I'm sure they got some money in the mail, which is usually how it works. 2 women were fired for telling a newspaper. This is a great one. 2 women were fired for telling a newspaper that they, along with a group of poultry workers, walked off the job to protest a new requirement that they pay 50 cents per hour. Pay 50 cents per pair of latex gloves that they used. Now, growing up in my life, I mean, I've worked in factories and construction and stuff like that, probably like a lot of people have, you know, and it's just like I had to provide my own work gloves. I worked in construction at one point. I had to provide my own work gloves and shoes and all that kind of stuff. So this one's kind of strange here. It's only some de minimis amount of money, 50 cents. However, these 2 women were fired because they thought that was a kind of a bad deal. And rather than keeping it to themselves, which is not what caused them to be fired, the cause of the firing was taking this to the media and telling a newspaper that this is just a terrible thing to them. That was protected, concerted employee activity, because in this case, the NLRB ruled that it says there were 2 women, but actually there were a whole bunch more that didn't say anything, and it applied equally to all of them. And so they were simply exercising their right of concerted activity. That doesn't mean they would win, but you have the right, the employees have the right to engage in concerted activity. They may lose, but they can't lose because they engage in the concerted activity. You see the fine line there? They have the right to redress. Okay, recent case law. Let's go through this real quick. This is some fun stuff here. There's a case here. This is a real new one. This just happened right at the end of June. It's not even a month old. It was Sodexo America, LLC. The National Labor Relations Board recently ruled that USC hospitals' off-duty access policy violated Employee Section 7 rights under the National Labor Relations Act. The policy prohibited off-duty employees from entering the hospital unless they were visiting a patient, receiving medical treatment, or conducting a hospital-related business, which the hospital's handbook defined as, quote, the pursuit of the employee's normal duties or duties as specifically directed by management. In other words, if you're not working or if you're not sick, get out of the hospital. Now, how about you? I mean, do you feel like it's okay to visit your employer on off-duty time? Well, here people come here on off-duty time. We work together. Seems like okay to me. But anyway, for whatever reason, the hospital had this policy. Maybe it was for security purposes. Don't know. The NLRB took issue with the specifically directed by management language of the policy. Specifically directed by management. That's a no-no. Finding that it provided the hospital with unlimited discretion to decide when and why employees may access the facility. The NLRB read the rule on its face as prohibiting employee access for purposes of engaging in protected concerted activity, while permitting access for other reasons as specified by management. It further reasoned that such a policy lacked uniformity in the sense that it did not prohibit off-duty access entirely. Rather, it prohibited access only when not specified, directed by management. So management could say, oh, you guys can come and hang out at the hospital and have whatever you want to do. Meet you, talk to your friends. But you guys over there, we don't authorize you to do that. Well, that doesn't seem fair. That seems like a mountain out of a molehill to me, but nevertheless, there was an issue there. So the NLRB found that the majority's holding was too restrictive, and specifically noting that it will limit the hospital's right to off-duty employee access for innocuous activities like collecting paychecks. Well, there's a good one. Completing paperwork. and filling out patient information. This ruling is the latest example of what is becoming an endless stream of NLRB activity on general employment practices. Hear that sentence, my friends. This is an expansive agency, the National Labor Relations Board. It's an expansive agency. It's no longer just about unions. It's all employees, and their rights are increasing. Now, you may not care about that, but when it comes and hits you smack in the face, I'm sure you will. Okay, more on protected activity and social media. I put more because, good grief, there's 8 gazillion things that talk about this stuff here. Now, on this one here, I'm going to summarize this, and then I'm going to make you a little bit of an offer here. Probably in your handbook, you probably do have, if not, you should have a very thorough clause that notifies employees of, what social media is. I mean, they know what it is, but you got to tell them what you know it is, and how it's to be treated and what you can and cannot do. Let me tell you, friends, this is a can of worms. It's a moving target. This is June 30th of 2012. Here's the good thing about this. There is actually a brand new policy that takes into account recent court decisions on social media, and it's a beautiful, it's just a terrific new social media policy. If you email me, I will send you a copy of this social media policy. If you don't, I won't send it to you. But anyway, that way you can take it and you can put it in your handbook, and you'll have a very up-to-date policy as of July of 2012. Okay, violation of the National Labor Relations Act leads to serious penalties. Discipline imposed pursuant to a company policy that restricts employees from any discussions of their wage rates may implicate Section 7. We talked about that. Section 7 protects the rights of the employees. On June 7th, 2012, the National Labor Relations Board issued an opinion in which it affirmed an administrative law judge's decision that an employer violated the NLRA when it fired an employee for disclosing wage rates in violation of the company rule. Handbook says, don't talk about how much money you make. This guy went and talked about how much money he made, and he got fired. And they got slapped big time. Big time. Wrong. Don't do that. So if you got anything in your handbook, get rid of that stuff. It's going to come back and bite you. I'm trying to see here what I can take out of this here. Okay, let's move on to this last one here. Do's and don'ts. I love this one because these are really simple pieces here. Now this is some guidance from the General Counsel, a guy by the name of Leif Solomon, who's the acting General Counsel of the National Labor Relations Board. This is very new stuff. Don't. Okay, let's do the don'ts first. Don't say this in your policy about confidentiality. Here we go. Number 1, don't say this. Don't release confidential information. Don't have it in there. If it's in there, striking it out of there. Number 2, don't share confidential information with anyone who does not have a need to know. Don't have that in there. These are things you don't want to do. Don't discuss confidential information online or in break rooms or at home or in public places. Don't require employees to do that. Actually, they have a right to do that. Here's another one. A handbook says, don't reveal non-public information on any public site, including financial information and personal information about another employee, performance, compensation, or status in the company. Now, one you got to read kind of carefully because under SEC rules, if it's a public company, you really can't reveal financial information. But the way this is kind of worded, they're talking about financial information or personal information about another employee. Don't have it in there because it just leads you down a road of not being able to talk about helping another employee. Another way of reading it. Here's another thing you don't want to do. Don't have this in your handbook. Do not disclose information about other employees or contingent workers. Here's another one. Don't have this in your handbook. Don't discuss pending legal matters. Tough call on that one because that one's probably on a case-by-case basis. But generally, the reason you're, if the legal matter applies to the employees, well, then it's a concerted activity. Here's another don't have in your handbook. Don't post anything that could be deemed material, non-public information, confidential, or proprietary. And then there's a long list of examples. Don't talk about the workplace except with your coworkers. That's dumb. No, they can talk about the workplace all over the place, and a lot of them do. And guess what? It's protected concerted activities. Okay, how about some things that you can do? Do say these things that I'm going to tell you now in your policy about confidentiality. Develop a healthy suspicion. Don't let anyone trick you into disclosing confidential information. That's a good line. Here's another one that you can put in your handbook. Don't post secret, trade secrets, secret, confidential, or attorney-client privileged information. Now, there's a special type of legal information. Here's another one you can put in your handbook. Don't disclose personal information except to those authorized to receive it. Well, that's just kind of common sense. You know, no, don't give your address or your social security number, that kind of thing. But these are things you can put in there that do not violate the law. And there are some things that I've already covered that you don't want to have in your handbook that if you do, you should take those pieces out. And so with that, I'm going to take some questions. We are now at 35 minutes past the hour, kind of right where we want to be. Let's see if we have any questions here. Raise your hand if you have a question, or if see if anybody wrote any questions in down here. Okay, I don't see anybody raising their hand. So if you want a copy of that latest and greatest social media policy for your handbook, not going to cost you anything except an email. You can reach me at craigd@davidsonmarketing.com. I want to thank you, everybody, for letting me bend your ear on this morning. And if you're in a hot place, I hope you stay cool today. Thanks, everybody, and have a good day. Bye-bye.